What exactly is bad faith bargaining? It sounds serious, and it is, but it's not always easy to define. Let's break it down. Surprisingly, the term bad faith bargaining isn't directly defined in Ontario's Labor Relations Act. But what is defined is good faith bargaining, and that gives us a starting point. Here's what the Act says. The parties shall bargain in good faith and make every reasonable effort to make a collective agreement. Clear as mud, right? That's where legal interpretation comes in, and where courts and arbitrators help us understand what bad faith bargaining actually looks like. Let's explore some of the most common examples. From years of experience in labor law, we've seen 5 common tactics that can land an employer in hot water with the labor board. Let's go through them. This is when an employer shows up at the bargaining table, but has no real intention of reaching a deal. It's all for show. Yes, tough negotiating is allowed, but refusing to budge on key issues, rejecting every proposal, or making offers designed to fail. That's not hard bargaining. That's surface bargaining. Imagine negotiating for weeks, only to find out the person across the table had no authority to make a deal. That's a major red flag. Sending reps who can't commit to anything wastes time, stalls progress, and violates the spirit of good faith. This one's big, and it goes beyond just collective bargaining. The Supreme Court of Canada has ruled parties must not lie or knowingly mislead each other about important issues during negotiations. In the labor context, that means employers may have to disclose major decisions, like plant closures or relocations, if those decisions are already made and directly impact employees. That kind of silence could be considered bad faith. If a party makes a promise during bargaining and the other side changes their position in response, that promise has weight. Pulling back after the fact? That's reneging, and it's a breach of trust. As the Ontario Labor Board has said, without reliability, no one could bargain in good faith at all. Refusing to attend scheduled meetings or even failing to recognize the union as the bargaining agent. That's not just uncooperative. It's a clear violation of Section 17 of the Labor Relations Act. So is bad faith bargaining always easy to prove? Not exactly. It's a fact-specific issue, and every case is different. But if your employer is using tactics like these, you may have a strong case. If you think your employer is bargaining in bad faith, don't go it alone. At Watson Palmer Labor Lawyers, we're here to help. With decades of experience in collective bargaining, we'll assess your situation and help protect your rights. Call us at 905-660-1499. Visit us at watsonpalmerlaw.com. Because when it comes to your future, bargaining in good faith should be the standard.